morning. Welcome to Law Power Hour. Good morning, George.
Good morning. Good morning, Barry.
Today we have attorney George Schoaf with us. I think I pronounced it after trying it 10 times in front of the mirror correctly.
It was wonderful.
And the most interesting thing about George, he's a patent lawyer.
Yes,
I looked at his beautiful smile and I looked at my teeth and said, we got him from the same dentist.
Thanks, Dr. Jaskolski.
Meanwhile, I wanted to have George on today because every night before I go to bed when I'm watching TV, I see an advertisement. We can help you get a patent. And it shows a design on TV. It shows people applying for patents. And it's a get-rich-quick scheme, I believe. I'm not sure of. Would you tell our listeners about it?
Oh, Barry, you're absolutely right. It is a get-rich-quick scheme. It is promises and beliefs that are not fulfilled, unfortunately. These invention companies are doing extremely well, and they're doing it by making promises to purchasers of these services that they simply won't fulfill. Generally speaking, and as I understand the way these companies operate, they will take substantial sums of money from people who are interested in obtaining a patent on an idea and promise a patent which they may ultimately deliver, but as opposed to a utility patent which covers and protects articles of manufacture, methods of manufacture, even software, and their utility, you'll often simply get a design patent, which is certainly a valuable work product, is not quite the sort of thing that I think people are generally looking for when they're contacting these companies.
Now, where do you practice? Tell our listeners a little bit about yourself, where you practice. Hold on, we got a call already. Good morning.
Good morning, Attorney Keller. This is a great show. I was just up last night, and I was listening to George Foreman that was talking about patent attorneys. Are you referencing those guys?
I'm having some difficulty hearing him.
He was talking about George Foreman.
Yes.
And George Foreman and the patents, and they were talking about that on TV.
Those are the sorts of patent companies to which I would suggest. There's an old Latin phrase, I'm sure Barry's familiar, caveat emptor, buyer beware. The sort of thing that you can generally anticipate from those companies are generally not what people expect when they go to a patent attorney as opposed to a patent company and provide sums of money for protecting their intellectual property.
Now, I was going to ask you about what you do. Now, you're a patent lawyer. You prosecute patents.
That's correct. I draft patents and then prosecute them. There's an entire process, and it's one of the very few in our government, apart from the IRS, that makes money, that people will file patent applications with the Patent Office. It's then examined by a group of specialists, experts in reviewing patents. There's some back and forth, usually, between the patent attorney that's filed the application and the Patent Office, generally engineers, PhDs, various scientific backgrounds and degrees. And finally, they come to an agreement after which the patent, a utility patent, and even a design patent issue.
Now, what's really interesting is the patent laws in this country are probably the oldest laws that we have on the books next to the United States Constitution.
Well, you're right. In fact, Barry, they are the patents are one of the several things mentioned in the Constitution. Specifically, our founders recognized the importance of patents in protecting intellectual property to a well-functioning system, and felt that inventors should be rewarded for their ideas, and that was good for an economy and good in moving a nation forward.
Now, in terms of getting a patent, things that are in the public domain, for example, like a baseball bat, you can't get a patent on a baseball bat.
That's correct. And let me just very quickly differentiate between the sorts of patents that are available. Generally speaking, there's patents for new and useful items. These are called utility patents, and patents for new aesthetics, something that has a particular look that you want to protect. That's called a design patent. And they cover fundamentally different IP. And as Barry mentioned before, for example, a baseball bat, as old as it is, isn't subject to patent protection at this point in time.
Well, I mean, the Louisville Slugger has been around as long as I can remember.
Correct. Now, suppose, on the other hand, somebody were to make a baseball bat out of a material that was entirely new and non-obvious and provided a real useful benefit, then perhaps we'd have something to talk about.
So if we made a baseball bat, say, out of titanium, for example, you might be able to get a design patent because it's made out of titanium.
Well, a design patent would cover the aesthetics, not the material of which the product's made. But if it were a material, titanium likewise being old, probably wouldn't be patentable as a baseball bat. On the other hand, if it's entirely new material, and scientists are creating new materials every day, perhaps so.
You know, every day, people who sit at home come up with new ideas, with new inventions, and they get pulled in by these companies that we referred to earlier. I don't want to say a disparaging remark about them because they do provide a service.
They do.
But it's probably more beneficial to sit down and have a consult with a patent lawyer to see what can be done in terms of protecting yourself.
That's absolutely right. Generally speaking, patent attorneys will meet and discuss with you, typically at no cost. I know at least that's my practice. What it is that you've identified as a potential patent, and we'll go through it, and then perhaps after that do some quick searching to see what may be out there in terms of prior art, and following that go to the patent preparation and prosecution phase.
Okay, let's break this down for our listeners. I'm playing cards with my friends. There's 50.
Are you winning?
Hopefully. There's 52 cards in the deck. I look at the deck and say, you know, I've got a new game I'm going to invent. And I want this to go to one of those big companies, you know, like the company that has Monopoly. I can't mention names of companies in the air, but I can mention the name Monopoly on the air. So I want to send it to them. So I come in to talk to you in your office and I say, can you help me? I've got a new idea here. Here's my game. I've written it out step by step by step, how you play it, how you keep score, what the results will be.
Sure.
Keeping score, in other words, you win money, you win this, you win that, how it's done, the whole process. What would you do when I walked into your office besides kicking me out? No.
Well, the first thing I do is say hello and I introduce myself, and I'd give you some background about the services that I provide. Then I would generally engage in a discussion about what it is that you've just mentioned, what it is that you believe, what it is that you're interested in protecting, and see how to best serve you in terms of the intellectual property that might be available. Now, we've just discussed patents so far, but there's a variety of other intellectual properties that can serve to protect your interests. For example, copyrights, trademarks, trade secrets.
Can you copyright that game?
There certainly are aspects of a game that can be copyrighted. Copyrights protect the expression fixed in a tangible medium. Now, what I mean by that is, for example, let's say I were to write a short story, and as soon as I've written out that, as soon as whether I printed it out, or whether I've typed it on a computer or written it on a page, as soon as it's fixed in that tangible medium, a copyright attaches. That means that I have a copyright in the work, and that once I file an application to register that work with the Library of Congress, I can protect that work from somebody stealing the work and using it as their own, or making derivative works for that matter.
Suppose that I shelf it, and then somebody else comes up with the identical program. Can I challenge their?
Are you talking about in the context of copyright?
Yes.
Now, what copyright protects, let me be very specific, is not the work itself, so long as it protects your work from being pilfered from someone else. In other words, let's suppose I wrote a software module that performed the function A, and someone else came along and likewise wanted to write, really liked what your software product did, but didn't have any access to the code that performed function A. They could, for example, and have done, go to a clean room procedure. That is, they could get a bunch of coders in a room who've had no access to your code and say, look, I want you to write a software program that does function A. They could, and so long as they haven't had access to your expression in the tangible medium, could do so without liability.
In other words, what you're saying is that they're not reproducing what I did. They're doing it
That's
independently.
exactly right. A copyright is, like it sounds, protecting the owner from copying.
Okay. You know, I see a lot of ads. We just talked about an invention in terms of a product like a grill, for example, or a griddle, or the orange frying pan, the no-stick frying pan. But I see a lot of ads for people to write books, and we're going to publish your book, and you're going to become an author.
Sure.
When they write the book, there's an immediate copyright that attaches to that, isn't there?
That's exactly right.
But when they publish it, they actually have to file to protect it, don't they?
That's exactly right. One of the problems we often run into is that people with a copyright to enforce haven't taken the initial steps of asking the Library of Congress to register their copyright. And in many circuits, including the 6th, which is the circuit in which Michigan resides.
He's talking about federal circuits.
And my apologies for
That's okay.
I tend to slip into lawyer speak.
He used to be a federal clerk, so he thinks in terms of.
Yes. In any event, with respect to what you've just mentioned, you need to, in the 6th Circuit, and this is an interesting little tidbit, you have to apply to the Copyright Office for a registration of your work, and the Copyright Office either has to register the work or deny registration. If either of those two events occur, you can sue for copyright infringement.
We're going to take a break for a minute because I'm going to ask you about photographs in a minute when we come back.
Thank you, Barry.
Okay, we'll be right back.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
So here's the situation. I'm driving down the street, and I see a beautiful rainbow.
Yes.
And I take out my telephone, take a picture of it with my camera, and and I want to call it Rainbow, and I want to sell it. Can I sell it?
Sure. The first thing I'd recommend you do before selling it, however, and we touched on this a few moments ago, is register the copyright. In the event then someone were to use that picture, you'd immediately have a cause of action for infringement.
But I couldn't sue them if they took a picture of a different rainbow. It'd have to be at the same place, same time, and same location.
Correct. Well, let's be clear about what a copyright protects. A copyright protects whatever it is you've fixed in the tangible medium. So they couldn't take your photograph of the rainbow then and likewise sell copies of it.
Okay, let me explain it in terms that you reviewed with me before the show.
Sure.
That copyright protection is like putting a fence around what you did at that moment in time.
Well, that was with regard to patents.
Okay.
Yes, with respect to a copyright, again, as long as the work hasn't been copied by somebody else, there's that old story about you put 1,000 monkeys in a room for 1,000 years, and one of them will type the works of Shakespeare, for example. And let's suppose that at that point, Shakespeare's works, which are at this point certainly in the public domain, had an extant copyright. Well, that monkey's work, because he generated it sui generis, would not be a violation of Shakespeare's copyright.
But the problem is that only humans can get copyrights.
You're exactly right. And you bring up an interesting story.
Now, listeners, listen up to this one. I want you to call in because this is really interesting.
Many may remember the all the to-do, the kerfuffle over the photograph of the monkey that the monkey apparently took of himself or herself. I'm not sure if it was male or female. As I understand it, the photographer had provided the monkey the camera. The monkey then clicked the shutter, and there was a big fight over who owned the copyright. And of course, the photographer asserted that the copyright belonged to him because he gave the monkey the camera in the first place. As it turns out, that wasn't the case. Since it was the monkey's activity that fixed the work, notably his face, in a tangible medium, in this case a photograph, it was no copyright. The courts determined that no copyright attached. Only humans can own copyrights.
Okay, now, I was just thinking of a really interesting problem that develops. I'm in Paris. I'm on the runway, and I'm taking pictures of all of these wonderful models. And
That doesn't sound like you, Barry.
well, let me finish, George. And the design of the clothes that they're wearing. And I run out the door, and I'm sending them off my camera to someone in China, and they start making the clothes. Does the designer have protection?
That's a good point, and it does. He would indeed. And in that case, you can see the copying link that would attach. Now, that assumes a few things. One, that the copyright on these new designs are in fact new, that the author of these dresses, and they're certainly dresses and patterns. There's a big suit, I believe, involving, who is the English company that does the plaid?
We never mentioned companies on the air, but I know
Oh,
who you're talking
my
about.
apologies.
Okay.
Burberry. Gotcha. Anyway, there's a suit involving a company that shall remain unmentioned, and somebody who's another party that's duplicated, so says the first company, its pattern in another work, and there's been a suggestion that that's a violation of their intellectual property.
Because somebody decided-
Copied another's
pattern.
design, correct.
Okay.
In this case, though, it's a trade dress claim, which is sort of a copyright claim in different clothing, so to speak. But yes, you can, getting back to your original point, Barry, you can certainly obtain copyrights on outfits, designs, dresses, any expression in tangible medium, and then it's protected like anything else. And in that instance, the one you mentioned, where photographs were taken, then delivered to China for duplication, the cause of action for copyright infringement would certainly lie.
Okay, now, if I want to come to your office, how do I find you to talk about my problems? In the
I
patent
am
world?
I'm currently at Butzel Long. I've been at Butzel for, we're going on 5 months, 6 months now. I started January 2, and I'm available anytime for a consultation. Please feel free to,
And you don't charge for a consultation, do you?
generally no.
If I want a patent search after I come in, though, I have to pay for that.
Generally speaking, you would, yes.
Typically, what's the charge for a patent search?
Well, it depends. There are many kinds of patent searches, and this. I know a lawyer saying it depends is something we learn. I believe that's first year law school, isn't it, Barry? But anyway.
Well, there's 2 points of view, but let's go on.
Okay. Well, in any event, there are different sorts of patent searches, and one that we typically recommend is it'll generally be on the order of about $1,000.
Okay, what does that involve? What do I get for the $1,000?
Well, we get experts in the field, very experienced in searching the prior art. And by the prior art, I mean essentially the universe as it exists before you file your patent application. And it seems fairly broad. It's because it is. And we will have experts who have spent their lives searching the prior art, looking for what they can find that's either the same as or closest to whatever it is you've identified as a possible invention.
Okay, now, you can't combine 2 items that are already in existence and get a patent as a result of combining the 2 items, can you?
Well, that's a great question, Barry. Actually, you can if that combination would be new and non-obvious. And in fact, many people argue that everything under the sun is merely a combination of old elements. And in a way, they're right.
Well, for example, I like to go fishing. So I take my tackle box
Mhm.
and I make it into a collapsible tackle box that I can take pieces off the tackle box and put them on my belt. And if I want to go wading, I have a portion of my tackle box with me without carrying that voluminous, cumbersome tackle box
Sure.
when I'm going down the stream fishing.
Mhm.
I've taken apart something that's already patented, a tackle box.
Well, but that part could be, or your method of putting the item together can be new and non-obvious. Again, it's a very fact-intensive inquiry.
That's the same thing with Velcro. When Velcro was invented, it came from some plant out in the desert in Arizona, and somebody saw how it caused things to stick together.
Now you're getting it very. You've touched on another very interesting issue in IP, and that is, if you read through, for example, a patent application that I've written, I don't use the term Velcro. Velcro is actually a trademark, and it's a trademark that's in danger for reasons I can talk about in a bit. But what we call it actually is a hook and loop fastener. And the reason we do so is because Velcro is the trade name of a company that developed the hook and loop fastener.
Okay. But it seems to me that the hook and loop fastener has been around for hundreds of years.
Not hundreds, but yes, for a while. It's certainly old.
Okay. So that was patented,
It was.
and the trademark Velcro, they have a trademark for that, but it's not patentable.
Well, no, it's not patentable. That's correct. It's a trademark. And what a trademark represents in the context of the IP universe is a source indicator. In other words, it's a consumer shortcut. Let's take Coca-Cola, for example. Coca-Cola, we've all had a Coca-Cola, I imagine, and come to associate it with the pleasurable experience. Some of us have. Some of us may prefer Pepsi. I'm a Coke drinker, incidentally. In any event, with Coca-Cola, let's suppose someone were to take the name Coca-Cola and put it on a T-shirt. Now, if consumers were likely to believe that this fellow that added Coca-Cola to T-shirts, that his T-shirts were somehow associated or affiliated with Coca-Cola, the same company that makes that pleasurable soft drink, then Coca-Cola would rightly have a problem with that.
So in other words, if I replicate their logo and their slogans without their permission, I'm going to run into trouble.
Correct.
On that note, we're going to take a break. Thank you.
Thank you.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
I was talking to you off the air about this myth problem. I remember when I was a kid, my brother used to come in with a sketch on a piece of paper, and he'd go running to my mother and say, Mom, give me an envelope. Mom, give me a stamp. And I'd say, well, what are you doing, man? You're addressing this to yourself. Well, once it goes through the United States mail, he used to tell me, once it goes through the mail, it comes back, it's got the stamp on there, it's already got the frank of the post office on there.
Proof of your conception of the invention on that date. In other
That
words.
was my point.
Right. And
Is that a truism?
well, you know, Barry, another excellent point. The United States, in contrast to the rest of the world, used to be a first to invent system. In other words, once you conceived of an idea, if you were the first and somebody else filed a patent application on the same idea before you, you were nonetheless entitled to the patent, even if, as I mentioned before, somebody had filed first. However, in 2011, 2012, we, the United States, moved to a first-to-file country. So that certainly used to be an issue, and that certainly did help you establish your date of invention. For example, in the context of, let's take an R&D department of a huge company. They used to have their inventors, and still do, and it's still a good idea, not only write down their day's activities and date them, they'd have another fellow or lady working in the lab come and review those notes and likewise sign, and that was their proof then of the date of conception. But since we've moved to a first-to-file country, that no longer needs to be done. That is an outdated mode of trying to protect an invention vis-a-vis your conception date. Now, the race, rather to invention, is to filing in the patent office.
Now, filing a patent is not a simple process.
It is not.
Okay, I want to go through that process. I want you to break it down because all the claims that you have about your product have to be included.
Well, they don't have to be, but they certainly should be. A good patent attorney will ensure that what's disclosed in the application is everything that has been invented. And that's why one need take care, and this is another reason to avoid these invention companies that we talked about earlier. One need take care in hiring his patent counsel. his or her patent counsel. And that is you want your patent lawyer to draft a robust specification, one that includes various embodiments of your invention. There may be a different way of doing something, or putting a screw here rather than there, or using a clasp rather than a hook. And it's up to you and your patent attorney to make sure that's fully included in your discussion of the invention that precedes the claims that conclude a patent. I don't know that anyone's familiar with the claim, but I'm sure Barry's got some great questions about that.
Well, in terms of breaking this down, let's pretend that I've invented a new sprinkler that goes on a garden hose.
Okay.
And it can either be mounted on a wall, mounted in the ground, or held in my hand. Okay?
Yep.
And I said that very specifically because you've got to make all those claims.
Mm-hmm.
And that's where the specificity comes in on the patent, correct?
That is correct. In your specification, you certainly better disclose the fact that this new sprinkler can be either put on the wall, mounted in the ground, or held in the hand. Now, a good patent attorney will be able to draft a single claim that will cover all those instances. But nevertheless, the specification itself should discuss each.
Okay, so when you discuss them, you have to describe the size of the sprinkler, correct?
If the size is important to the invention, yes.
Okay, if it's handheld,
Yep.
describe.
Mm-hmm.
And if it's got a place for your fingers on there, for example, to fit, it all has to be included.
Yes.
Okay, so it has to be specific in terms of the claims that you're making.
Yes. Anything that you want to claim in these claims of the let me just take a step back really quickly and for our listeners discuss patents. You go to Google Patents and search anything and pull up a patent and take a look, and you'll notice that each patent ends with a series of numbered sentences. Those are called claims, and the reason they're sentences is a holdover from the old days. This is simply how we draft claims. That's the way the Patent Office reviews them, and it's particular to the Manual of Patent Examining Procedure, which is sort of the rule book for practice in front of the U.S. Patent Office. These claims, as I mentioned to Barry earlier, can be likened to, let's say, for example, you have a house with a fence around the yard. The fence defines your property rights. In the context of a patent, it's the claims that comprise the fence, through which no one can trespass, and in the event they do, you would have a cause of action. So when I'm referring to claims, that's what I'm talking about.
Okay, so getting back to the sprinkler,
Yep.
or the nozzle, whatever you want to call it, and how it works, you have to describe whether it has control on it,
Mm-hmm.
how you set the control,
Sure.
how you shut it off,
Yep.
and it has to be specific.
Yes.
Having done all that, can I file my own patent, or do I still need to have a patent lawyer? I'm not a patent
No,
lawyer.
you
I'd
are-
have to come to you
Yep.
to file the patent.
You are permitted a couple of things about, in order to practice in front of the U.S. Patent Office, in terms of representing somebody else, you have to, we not only take a state bar to be recognized as lawyers, we also have to take a patent bar, which incidentally is considerably harder and has a lower pass rate than the bar for lawyers. And you have to have certain scientific qualifications. I, for example, was a biologist in another life. That being
He
said,
said in another life he was a biologist. He probably created
well, funny thing is I've had exactly one case that's involved my background, and all the time I've been out in Detroit, a mutation that was responsible for canine von Willebrand's disease in dogs, obviously. In any event, getting back to the question, repeat it, please.
No, why I need to go
Oh,
to
yes.
a patent lawyer instead of just to the local lawyer for the patent because of all the requirements that must be
Yes.
met.
You-
Otherwise, your patent will just be sent back and it'll be rejected. won't it?
Exactly, exactly. There's very specific procedural aspects that have to be followed, not to mention the art in patent drafting is in the claims. This is the fence that I mentioned earlier. And it's not only a patent attorney that you want to draft your application, it's a patent attorney with experience because claiming is an art. It truly is. I have been in the unfortunate position of trying to enforce patents that had been written by folks who tried to shortcut the process and draft their own patent. And to suggest that that's anything less than a mess would be incorrect. It is an awful experience. And frankly, if you have an invention, it is worth the effort to at least have a consultation with a patent attorney to discuss what your options may be.
And did you hear the word patent attorney? How do we get a hold of you, patent attorney? Give us your telephone number.
You know, I would give it to you. I can tell you that it's but so long, but I don't have it by heart. That's not one of the things I keep in my
Okay,
gray
so
matter.
About so long in Detroit.
Yeah, at 150 West Jefferson Avenue, Detroit, Michigan. I'm also a Detroit resident, incidentally. I live a mile and a half from where I work, which is one of the great pleasures in life, frankly. But the phone number, I don't have it readily at hand. And my apologies. I should have been better prepared.
If anyone wants to get a hold of George, just call me at 248-335-9266, and I'll hook you up. Now, let me ask you a question.
Sure.
I'm going to the gym, see, and I want to take my coat off.
Uh-huh.
I don't
To
have
show
a
off those
hanger.
magnificent pecs.
Yeah. And I don't have a hanger. So I said to myself, well, why don't I come up with a collapsible hanger? So the first thing that would happen is I'd go over to your office and say, I need some help. I've got an idea. I'd have to have a drawing, wouldn't I?
Well, not necessarily. We can do drawings, but a sketch will generally help. What do they say? A picture's worth 1,000 words. If you can sketch out what it is that you've thought about, that would help.
But a
That would be
hanger's a
helpful.
hanger's a hanger. So what's the difference between just getting a hanger from the cleaners, folding it up, and just
Well,
working that metal until you can use it again, or making a collapsible hanger?
well, it depends. I'd have to do an art search. It depends on how the hanger collapses. There's any number of ways that might make your collapsible hanger new and non-obvious.
Sounds like a good idea to have a collapsible hanger.
Sure does. Yeah, I can tell you that when I go to the gym, I just leave my stuff on the floor. And often it's not there when I get back.
Well, some people hang it up. Some people come back to surprises. It's on the floor anyways.
That's right.
And some people come back to empty lockers, but that's another problem. We're not going to address that today. Having said all that, the collapsible hanger issue would be an issue that I'd have to undertake.
Yeah.
So there you go. I'm sure lots of our listeners have ideas that they want to patent, and I challenge you to call us this morning with your ideas. But in the meantime, I see all these new brews that are coming up.
New brews.
brews,
Oh,
yeah.
the craft beers?
Craft beers are craft beers. Can you get a patent on a craft beer?
You can, or a recipe. But here's one of the problems with that. Let's talk about Coke again, if you don't mind.
Well, you got to be careful when you talk about Coke.
My apologies.
Because
Let's-
when Coke originally came out, it was used as a cough syrup.
That's right. And one of the bargains in filing a patent, for example, and getting the limited monopoly that the government provides in the event the patent issues, is you've got to tell the world your recipe for your craft beer. And then let's suppose your craft beer is a huge hit. 17 years later, or 20 years after filing, I believe the term now is 20 years after filing the application, that falls into the public domain, which means anybody can make that craft beer, make and sell it. So let's talk about that soft drink that I've mentioned before. There's other alternatives to protecting your IP, and that is keeping it a trade secret. And those, in theory, assuming you follow the correct procedures, can last in perpetuity. Coca-Cola, and I apologize for using the brand name again, has been able to perpetuate and continue to exclusively use its formula because it's maintained that formula as a trade secret. I understand it's tattooed to the back of some young Russian woman.
Well, the same thing applies in the United States with Botox.
Yes.
That's a trade secret.
I
I know it is.
Could be, yeah.
I happen to know that Botox is a trade secret. So if somebody gets close to it, they can say it's like Botox, but they can't say it's Botox.
Botox, is it a trademark, perhaps? I'm not, yeah. You can call it whatever you want so long as nobody has a trademark on the term, and people would be confused as a result. If it's a trade secret, I'm not quite, I guess I don't understand the question.
So if I have a trade secret and I want to keep my craft beer safe,
Yes.
all right, let's break it down. Forget the craft beer for a second. I'm growing at home.
You're growing.
Yeah, I'm growing. Okay.
What?
I'm a healthcare provider, and I'm providing marijuana for people, and I'm growing at home, and I've got a particular way of handling my seeds.
Yes.
It could be a trade secret, right?
Sure, absolutely. And you could protect it into perpetuity. Let's say you got plants as a result of your cultivation with a particularly high THC level, which I believe is the operative ingredient.
Well, that's what Eli Lilly's working on right now, believe it or not. They're coming up with their own seeds.
Yeah. Well, and that brings up another interesting aspect, believe it or not. There are plant patents as well, another branch of patent that's available in the U.S. A lot of the wonderful apples, the seeds that are growing these, what's the really, it's the wonderful apple. Those seeds are all subject to patent, and as a result, can't be.
Honeycrisp?
Honeycrisp, that's
Right,
it, yeah.
that's it. Honeycrisp it's like a common everyday term now, like Macintosh apple.
Yeah. Although I prefer Honeycrisp, and the seeds of the Honeycrisp, if I'm not mistaken, are subject to a U.S. patent. And the end result is only the owner of that patent can make, use, sell, and offer to sell, absent license, that particular variety of apple.
Okay, so you can actually do that if you've got, what I'm trying to establish for the listeners out here is if you've got a formula for making a particular drink, you could get a patent or you could keep it as a trade secret.
Correct.
And when you keep it as a trade secret, you just can't share it with anybody.
That you have to take a number of steps to protect the trade secret.
Tell us what to do.
Well, certainly there should be confidentiality agreements associated with it. There has to be to constitute a trade secret. It has to have an economic value. But again, the upside of the trade secret vis-a-vis the patent is it can last potentially into perpetuity. Now, here's where, on the other hand, the trade secret suffers in terms of the rights provided a trade secret holder. Anybody can reverse engineer it. And anybody can, if somebody figures out, for example, how it is that you've grown your marijuana seeds or how it is you've cultivated your marijuana seeds without misappropriating your trade secrets, they can go forward, even if the plant that results is identical.
But
in contrast, that's not the case of patents. You cannot reverse engineer anything that's the subject of a patent. You can certainly try to design around, but not reverse engineer.
so the preferred way is to go with the patent for protection.
This is exactly why you should consult your patent attorneys.
That's why I raised the question.
Exactly. Generally, the scope of rights provided under the Patent Act, a limited monopoly for a period of time, can be preferred in many instances, yes.
Well, what's the length of a patent?
It, again, subject to some, well, it's not so recent any longer. I'm getting old, Barry. A patent now will survive subject to some various factors 20 years from the date you file the application from which the patent matures.
Can I amend my patent and spin off other patents from that patent?
You're exactly right. And I know, Barry, that you're somewhat familiar with this process. You can take continuations in part off that application. What often happens, though, is the patent office will ask you to file a terminal disclaimer on these additional patents that you file. So you can't. I think I get what the approach is. These continuation applications that spin out get the same filing date as the original application to which they claim back.
So they relate back to the original filing date.
Exactly.
Okay, so if you file a patent on 6/1/2018 and 15 years out, you decide to amend it, it still relates back to the first date.
Well, let's another bit of procedural. You cannot, subject again to some caveats. Once a patent issues, you can now no longer take continuations off of it. You can ask for a reissue, and up to 2 years later, and change the patent. For up to 2 years, you can, and I should be more particular and specific, you can change mistakes. You can't add anything to the patent at the reissue proceeding. You can do a broadening reissue, subject to intervening rights. But that being said, once a patent issues, the game stops. So one of the things that often happens in our practice is just before a patent is about to issue on an application, is we'll recommend, and again, another reason to hire patent attorneys rather than these invention companies, is we'll recommend a client take a continuation off that application to keep the string alive. Because I can tell you this, as a patent attorney, it's much easier to draft a claim to a product that's sitting on your desk if you want to cover it for infringement purposes than it is to imagine what may come out.
I want some of you listeners to call in now and congratulate George. He just passed the oral portion of the patent exam.
My apologies.
Okay, it's very complicated.
It is.
Okay, break it down in simple terms of what they can do. Come on, George.
Okay. In terms of coming into filing, well, generally here's how it proceeds. We'll have someone call in and say, "Look, I've got an idea," and I'll invite them down to the office. We'll discuss their idea, and then I'll make recommendations. Generally speaking, our first step will be, because these are people typically that are skilled in the art, these inventors that come in with these new ideas. Sometimes it's not. It can be anybody. Who knows who's going to have that moment, that moment of clarity, or that flash of genius. Who knows? In any event, I'll recommend that they come in and we'll sit down and we'll talk, generally for an hour or two. And this is all just to sort of hash the ideas out. I'll push and poke and make sure we've captured the essence of what it is that you're interested in. After that, typically, I'll recommend that we do a patent search, because I don't know the world as it existed before you've come up with your idea. It's just impossible to know what may be out there. And I even recommend Google, again, I'm sorry to continue to raise that. They have a patent database that allows you to search what's out there. And you even may do a simple Boolean search on Google to see whether or not what you think you've discovered is out there, or just a Google search.
A Boolean search is a general search,
yeah.
So people understand that.
And following that, we'll do a search. I will typically then review the results of the search and provide an opinion on what may be available in terms of patentability. Then, if it looks like the client is interested in pursuing a patent, what we'll do next is I will draft an application that includes claims and drawings, as Barry mentioned earlier, present those then to the inventor for review and discussion. We'll make whatever revisions and changes are appropriate and file it with the patent office.
So the first round's going to cost you $1,000 to find out if you have a chance to get in the game.
Right. And then
then
generally speaking, with the patent application and drafting process can run anywhere from $3,500 to $10,000, depending on the complexity of the invention.
But for $1,000, you'll know going in whether you've got an
That's right.
opportunity to pursue it.
And there's some cases where people decide, let's go blind without doing the search in the first place, and we can do that. The unfortunate aspect of that, then, is you're sitting behind whatever it is to get the application published, and the patent office may find a piece of prior art that is exactly what it is that you think you've invented. And in that case, you are DOA.
You're rejected from the patent office.
That's exactly right.
And you can come back and challenge them.
You can, but art is art, and generally you're not going to win if something existed before you were there with yours. You're dead in the water.
Well, George, thanks for coming today.
Well, thanks for having me, Barry. I really appreciate
Hope
it.
you come back again.
I'd love to.
And we'll get you to break it down a little more.
Thank you so much.
Thank you.